Good morning, ladies and gentlemen. Since I am the substitute to James Thornton, who should be here, allow me one word about myself. I was successively judge in Germany, official with the European Commission for about 30 years. I had made an academic career as professor in environmental law, and I'm now in private consultancy on environmental law, working with closely with ClientEarth. The Aarhus Convention, on which I'm to talk this morning, is a convention on access to information, public participation in decision-making, and access to justice in environmental matters. It is called Aarhus Convention because it was adopted in 1998 in Aarhus in Denmark in the context of the United Nations Economic Commissions for Europe. This is the whole body, which I will explain shortly. The convention entered into effect in 2001 and is by now ratified by 44 states in Europe and the European Union. The United States and Canada are also part of this European Commission, Economic Commission of the United Nations, but they did not sign the convention. Probably there were too many rights for environmental associations and individuals. Switzerland has not signed either, and Ireland not either. However, Ireland is a member of the European Union, and as the European Union has ratified the convention, Ireland is bound, and all its legislation, jurisdiction and administration is bound by the convention by virtue of this Treaty on European Union. Thank you. The convention introduced also an amendment to the procedures of genetically modified organisms, which, well, for United Nations reasons, it's not yet in force. It's quite simple. There is a need of 27 states ratifying this amendment. 26 have ratified, and among the 26 is the European Union, which has ratified for its 27 member states. So all 27 member states of the European Union are bound by it, and this would make much more than 27 member states under the United Nations system. However, the United Nations do not count the European Union with the number of its member states, but count it only as one. So this is a little bit a tricky issue in this Aarhus Convention. What is new in this Aarhus Convention? I cannot resist the temptation as saying to my colleague from the European Environmental Agency, the first news is that since 2006, the European Environment Agency is obliged by virtue of the Convention and of European law to issue the state of the environment every 4 years, not every 5 years anymore. But this has not yet come until Copenhagen, though it is in legislation. What is more relevant for our discussion today, this convention grants rights, individual human rights to environmental information, to participation, and to access to justice. And let me explain in 2 words why this is like that. I was involved personally in the 70s in the discussion whether we should amend the Council of Europe Convention on Human Rights by adding a right to a clean environment to this convention. And there was a lot of discussion, and the experts could not agree. What does it mean in practice? Should everybody have a right of a garden or 1 square meter of nature, or what does it mean? And so there was no outcome out of that. And finally, they decided that there should be a substitution, that there should be procedural individual rights in the environmental sector. With a simple consideration, the environment is not the administration's property. However, in our societies, administrations take decisions on permits, on infrastructure projects, on monitoring, on all sorts of issues which we have been discussing yesterday and will be discussing during these days. Now, as the administration is not the owner of the environment, this decision-making should be shared with civil society. And therefore, a right of individuals of civil society to participate in decision-making. And in order to be able to participate at the same footing as the administration, there is the right of access to information on the environment, on all issues which are in the hands of the administration. This is the concept, and if there is litigation, if there is dispute between the administration and the individual or the NGO, we have in all our societies courts as independent, as neutral arbiters, which should decide on these things, and therefore there's right of access to information. Now, the first issue, the access to environmental information, gives a right of access to information in any material form. So whether it's an email or it's in book form, whether it's a study or whatsoever, any information which is materialized is accessible. The convention enumerates quite in detail what is an environmental information. It is also environmental information on genetically modified organisms, on substances and energy, radiation. European Union law, which goes one step further, even indicates that anything, any discharge, any emission which goes into the environment is environmental information. And this goes very far because, again, the environment is not the property of a company or of an administration. And whoever releases things into the environment, it's the same as if you release a product on the market. You can't say this is confidential because you have put it on the market. And the same has to be applied with emissions, discharges, or other issues which go into the environment. As soon as they are released from the emitter, they are in the environment, and therefore they are and should be public. The convention indicates that economic analysis, assumption, impact assessments, cost-benefit studies, and all these things are environmental information and therefore are accessible. Then on information on the state of human health and safety, conditions of human life, are environmental information. Environment in European Union law, and the convention is not far away from that, includes all the time also human health. This should not be forgotten. The access to environmental information, which is in the hand of the administration, is there's a right to that without an interest having to be declared. You need not say that you want it for a study or for your PhD or for just private curiosity. Therefore, any citizens from Copenhagen or from Roskilde would be allowed to ask the mayor of Madrid what about the quality of drinking water in Madrid, without having an interest to declare why he wants to know that. And the same would apply to drinking water in Copenhagen or in Stockholm or wherever. European Union legislation for these 27 member states, and David Quist told us yesterday that Norway takes over quite a number of European Union legislation, so de facto this legislation goes even beyond the European Union, has transposed and versed this Aarhus Convention provisions into specific rules. We have a directive on access to information. I should just explain for those who are not familiar. A directive is not what the name says. A directive is a piece of legislation which is binding. It allows member states some flexibility to say to do how they want to make it applicable. But the result has to be achieved. The directive is a binding piece of legislation. There is a directive on access to information, on participation in decision making, on environment impact assessments with regard to projects on environment impact assessments with regard to plans and programs. We do not have, and this is an issue which I find interesting for this conference, we do not have legislation on general environmental product safety. There is a directive on general product safety. However, this directive does not include the environmental aspects of that. It includes health and safety of individuals, but not of the environment. Then there's a regulation of applying the Aarhus Convention to the EU institutions. The European Union is some sort of regionalized globalization mechanism. And of course, many decisions, GMOs, now permits for quite a number of pesticides and so on, are nowadays being issued by the European Union. So all the more is it relevant that this closed shop at European level be open and transparent, and therefore a specific regulation applying to the EU institutions. Excuse me for the typing error. It's a regulation not from 2001 as it is indicated, but from 2006. And it is there where you find the 4 years commitment for the European Environmental Agency. The answer of the administration must be given in 1 month. Silence by the administration is treated as a refusal of information, and incomplete or refusal of information entitles the individual to go to court. There are a number of exceptions which are enumerated. One of the Aarhus Convention is interesting, the confidentiality of commercial and industrial information, where such confidentiality is protected by law in order to protect a legitimate economic interest. We have in European legislation on pesticides in particular, but in REACH also, quite a number of things that a company may claim confidentiality of information. This must stand the test against this legislation. Is it really a legitimate interest of the company? Is it really protected by law? A company can't just say anymore that something is confidential. The confidentiality of personal data, but however limited to natural persons. So company do not have a right of privacy under the convention and under the European Union legislation. Confidentiality of proceedings of public authority is an intricate issue. The convention provides that these exceptions have to be interpreted narrowly, and in particular where emissions into the environment are concerned, normally the transparency issue should prevail. This right of access to information transposed into the European Union law, the treaties on European Union, the Lisbon Treaties, mentions 5 times that the administrations in the European Union, European and national, shall be open and transparent. This principle of an open society is quite a fundamental right under the Convention and under the Charter of Fundamental Rights, which the European Union has adopted. Now, all this is very nice, but the problem is a little bit the human rights are some sort of platonic ideas. There are enough ladies in the room, and I just would like to remind you of the fact that we have a human right of gender equality since 50, 80, 100 years. Still in the European Union today, the difference of salary for the same job is 22%. We are, and the ladies must know that, or at least they should know that unless you fight for your rights, the platonic idea of equality or of any fundamental right remains a platonic idea, but not more. The same is true with access to information, with participation in decision making. Unless you go for your rights and as individuals, you will not manage to change the mind of the administration. Knowledge gives power, and if the administration has to share power, has to share knowledge, it has to share power, and that it doesn't like. So you got to get active in order to get it right. We can see it we have in a number of constitutions, really the fundamental constitutions of member states, France, Spain, Portugal, Greece, and so on, a right to a clean environment. But if you look at it in practice, 5 minutes? Thank you. If you look at it in practice, it does not really work because it is not made operational. And this remains the big problem. I will have to speed up a little bit. Participation in decision-making is imperfectly organized. We have a mandatory right of participations for permit decisions, for construction projects, infrastructure projects, and so on. And the convention indicates that it shall take place when all options for the decision are open. We do not have such a right under the Aarhus Convention for participation in decision-making on authorizing, permitting a car, or permitting a pesticide, or permitting a GMO. As I said, for GMO, it is now gradually coming. The provision in the Aarhus Convention is listed down. Each party shall provide for early and effective information and public participation prior to decision-making on whether to permit the deliberate release into the environment and placing on the market of genetically modified organisms. A clause which has to be poured into practice. European Union legislation is relatively poor on that. I will not go into details for lack of time. EFSA makes some sort of formalized participation, but it is not used by civil society. Access to the court, against refusal to grant access to information, against the refusal to allow participation. For the rest, it largely depends on the national legal order to what extent access to courts is granted. The Aarhus Convention does not contain an enforcement procedure. There is a compliance committee which examines compliance with the Aarhus Convention, but this is difficult procedurally. NGOs and individuals make little use of the opportunities offered by the Aarhus Convention, and the fundamental right of access to justice is in a rather disappointing way implemented in member states. Let me conclude, this is the last slide. What we need is certainly in the Aarhus Convention and in the operational systems of European Union legislation, a more consistent approach, recognizing and using more strategically these rights given, a more coherent approach. It doesn't make sense to have an environment impact assessment for projects, plans and programs, but not for products. GMOs, nanotech, we have quite a number of these issues. A systematic study, a publication of studies which are paid by the taxpayer, that should be the first obligation of the administration, that these studies are made accessible, but they are not for the moment. A collection of all the points which we are discussing here, these alternative discussions away from mainstream, they are dispersed all over Europe, I would say even globally. But there is no concentration somewhere where you can find alternatives to mainstream information. We would need a European Union legislation on product safety with regard to the environment. Yesterday, from your remark, Madam Chairman, I included this observation. We need a European Union legislation, perhaps a global convention on corporate, environmental and social responsibility, that whenever a European company goes to Africa or Latin America the European environmental and human rights standards are applied wherever it is active. That is the most simple form where European Union could make true its promises of human rights and democracy. And we need democrats. These rights of the Aarhus Convention are democratic rights. But where you do not have people who fight for these rights, all this is just good speaking, but not really worthwhile. It is disappointing to see how little information is requested from administration, how seldom administrations are asked really to open up, to show information. And of course, the absence of transparency and openness does not work in favor of environment, does not work in favor of citizens. When we see, and this is my last phrase, Madam Chairman, when we see in Europe at least, those countries who make an active, progressive environmental policy, Finland, Sweden, Denmark, of course Norway not being a member of the European Union, but perhaps the Netherlands, to some extent Austria, to some extent Germany, they do not fare less well in economic terms than countries which reject environmental issues. So it is a myth that environment causes jobs, causes economic competitivity and inflation. But the environment itself has no voice. It needs the voice of citizens, of Democrats. And that's all I wanted to tell you about these issues. Thank you.